Here they come. Hello, everyone. Welcome. Welcome to the first webinar of 2022 for Stein Financial Group. See a lot of people popping in here, so we'll give it another couple minutes, maybe just one more minute here before we get started. And before I get to introduce you to our presenter today, Brad. Of course, you all know who Anthony is there up on the screen.
Hey, everybody.
In case you don't know who I am, I'm Kimberly Hamlin with the Stein Financial Group as well. Hopefully you're seeing my name fly around on some emails and things like that. Let's see here. All right, well, I think we got a pretty good crowd coming in here. So Brad, we'll go ahead and get started. Everyone, this is Brad Frank with the Barnes Thornburg Group. He is a partner and been an attorney with them for almost 20 years. And so really excited to have him here today to visit with us about estate planning. It is one of the things that he does in his practice. So he has a lot of experience in that space. And I even wanted to read something that his clients say about him that I found on their website. So don't let me know if I'm going to embarrass you, Brad, here or not. Yeah. But it says that your clients really appreciate your breadth of knowledge, your ability to answer a variety of questions with ease, and a can-do attitude that you have about things, which I think is awesome. And I think that's great high praise for what you do and being in the legal space. So thank you for spending time with us today, and I'll turn it over to you.
All right, thanks. Thanks so much, and I'm glad to be here. I'm a partner at Barnes Thornburg in Minneapolis. I'm actually physically in my office right now. And I'm here to talk about estate planning. You know, the title of the presentation is Estate Planning in Uncertain Times. When I initially titled it that a while ago, that was more about uncertainty as related to tax law. But now, you know, so much of our world is uncertain. So I guess unfortunately, maybe the title continues to work. So when I talk about estate planning, what is sort of on my mind? I'm generally thinking about a few different things. One is certainly asset accumulation and also wealth preservation, but you know, those are things I'm not really going to meaningfully talk all that much about. You know, the Stein Financial Group certainly is able to help you with the accumulation phase of your estate planning. I'm more here to talk about planning for what you do with the assets once you've accumulated them or as you continue to accumulate them. You know, as it relates to wealth preservation, there are certainly like creditor protection aspects to estate planning. I'm not really going to dive into those today. A different type of wealth preservation is what you'll hear referred to as medical assistance planning or nursing home planning. That's also not something I'm really going to speak about in detail today, other than to say if those are things that are on your mind for yourselves or maybe for family members, those are areas where you'll want to get specific expertise and specific assistance. You don't really want a lawyer or other kind of planner who kind of dabbles in those areas. They're very specific, they're very technical, and they're constantly changing. So I would recommend that you seek out very specific advice if that's something that you're sort of focused on in your planning. What I'm really going to talk about today is distribution of your assets in a few different areas in ways that are tax efficient. We'll talk a little bit about the estate tax and gift tax system, ways that are cost effective, that gets into probate. And then, you know, what's probably most often on people's minds is just making sure that your assets get distributed and managed in line with your goals. And then more and more, a big part of the conversation around estate planning for our clients has focused on what to do if somebody's incapacitated. So you're still here, you're still alive, but you're unable to manage your assets. And again, that's something a lot of us are thinking about or dealing with for ourselves, or also regularly for maybe other family members. Also, you know, I didn't mention this as we go. Please feel free to put questions in the chat or send questions into the question function, and we'll take them either as they come or at the end, whatever seems right. So you all have an estate plan, whether you've sort of affirmatively done one with a lawyer or any other professional, or on your own, maybe online in the past. And the first place that most of us really sort of, whether we mean to or don't, obtain an estate plan is through the way we hold title to our assets. So if you own assets jointly, so maybe you might own an investment account as joint tenants with the rights of survivorship. Or a lot of us own our houses. If we're married, we own them jointly with our spouse. And those ways of holding title serve effectively as an estate plan, because they say when one of us passes away, here's what happens. It goes to the survivor by operation of law. And so that, whether you realize it or not, is sort of essentially an estate plan. Additionally, and we'll talk a little bit more about this in a bit, the way you have beneficiary designations on assets, whether it's a beneficiary designation or a transfer on death designation or a payable on death designation, all those things will operate to distribute the assets the way you state in those documents. And so you've got to be thoughtful when you put those in place. And so for some people, if their assets are assets that are easily distributed by a beneficiary designation or the way they hold title, and maybe you're okay just handing all your assets to whoever your chosen beneficiary is outright, sometimes focusing and sort of relying on beneficiary designations will work just fine to get assets where you want them to go. But a lot of people want to otherwise understand the other options available to them when they look at an estate plan for various reasons, whether it be tax related or related to the way distributions are made. So the next step, maybe from asset titling, is the law of the state of residency. So in Minnesota, which is true in most states, what the law says is basically if you pass away and you're married, your assets go to your spouse. If you're maybe not married but have children, your assets will go to your children, and sort of down the line, children, grandchildren, etc. If you don't have a surviving spouse, don't have surviving children, but are survived by parents, your assets will go to your parents. It's called your heirs at law. And then if your parents are gone, your assets will go to your siblings. And then if they're not around, nieces and nephews, and then sort of out into the universe of cousins. And this is all actually what I'm describing is essentially what the back and forth and the disputes in Prince's estate were really about. Were about who made up his heirs at law. Again, for some people, that sort of general path of distribution sounds just fine. Again, it may not be the most tax efficient way to do things. It also may not be the way you want to leave assets to people, because you're, through that path, whoever the recipients are would get the assets outright. And some people just don't want certain individuals or classes of individuals in that order to receive assets. Sometimes when I'm describing this to clients or potential clients, they're kind of tracking like, okay, spouse, that makes sense. Kids, fine. Grandkids, great. Parents, okay, fine. And then maybe we get to siblings, and then sometimes people start to ask what other options they might have. So the next step up would be a will. And your will is what I think a lot of people understand it to be, which it says, when I pass away, here's how my assets are to be distributed, any assets I own in my own name, and here's who I'm appointing to administer my estate. That person is called a personal representative. It's the same thing as an executor. It's just a more updated legal term. And then, within a will, you can say people get their assets outright. You can say they get them in trust. You can put all kinds of restrictions or permissions in there regarding the assets and the way they're used, and who receives them. But so those are all the good things about a will. The downside to a will is any assets you own in your own name, before they can be distributed pursuant to a will, they have to go through a probate process to be allowed to be distributed. I'll talk more about probate in a second, but a lot of people, either through personal experience or anecdotal information they've received from friends or family, decide, I really don't want to deal with the probate process. And so if that's the case, but you still want to exercise the kinds of controls that are available to you through a will, the next option is a trust, a revocable trust. And what a trust is I've heard some people over the years call it a will replacement, but what it is it really works very much like a will. It says, when I pass away, again, here's who gets my assets and in what manner, and then here's who I appoint, in this case called the trustee, here's who I appoint to administer my assets and distribute them out as I say. The big difference being, if you have a trust, a revocable trust, and during your lifetime, you take assets that are held in your own name and retitle them into the name of your trust, when you later pass away, no probate will be necessary because the trust acts basically as a sort of a global beneficiary designation to take them out of the probate process, because you don't really own title to the asset when you pass away, your trust does for these purposes. And that way you avoid probate and your estate can more easily be distributed to your chosen beneficiary. So I keep talking about probate, and so some of you out there may have dealt with probate, again, in your own families or for parents, in-laws, whomever. So what is it? It's a court process to clear title to assets. It's an informal court process. And over the years, some people have come to think of it as sort of the end of the world. Is it? No. How close it is to the end of the world kind of depends on what jurisdictions we're talking about and what kind of assets we're talking about. So probate for assets just in Minnesota really has become not that big a deal. Even before the pandemic, the Minnesota courts, probate courts, were becoming much more streamlined and using e-filing and email more regularly. And so it's become much more user-friendly and therefore also timely to administer probates here in Minnesota. But even for the most simple probate, there's still some sort of usually three general complaints about probate. The first is that there's some time lag associated with getting access to the assets that are subject to the probate. That can be weeks, not months necessarily, but it still is a delay. And it can be a real issue if maybe person passes away, had all their assets in a bank account in their own name, and you really need them to help pay for maybe spouse's needs or whatever, and you need to get probate up and running to be able to access those assets. The second reason people don't like probate is there's costs associated with it. So even again, for like a truly simple probate, the cost between filing fees and attorney's fees are going to usually run at least maybe $1,500 to $2,000, and that's sort of on the sort of bare minimum side. And then the other reason people don't like probate is it is public. And that's not to say that in most cases that there's like an open court hearing where there are lawyers arguing and people taking testimony and all that kind of stuff. Like that happens, but it's relatively uncommon, and it's usually, that's when something's wrong, like a will got lost or the siblings are fighting about something or whatever. But in any probate, the information is public. And so a lot of people don't like the idea of there being sort of, even there's somewhat general statements, but nonetheless statements out there about, when this person passed away, they had these classes of assets that were worth roughly, X, Y, and Z. And I think a lot of people don't love the idea of that information just sort of being out there to be viewed by whomever. And so those are sort of the general complaints about probate. That being said, in Minnesota, on its own, probate's not that big of a deal. But in states, Minnesotans tend to like to have second homes. And, if you own real estate in a jurisdiction in your own name, when you pass away, that would likely cause a probate in that jurisdiction. So in Wisconsin, probate from a filing fee perspective is particularly expensive. In Florida, it's expensive both from a filing fee and attorney's fees perspective. Texas, Arizona, California, sort of same, you know, the Sun Belt and Wisconsin are some of the worst probate states. And so, you know, Minnesotans often are dealing with probate or probate concerns in those states. And so probate just in Minnesota, not the end of the world. Probate in multiple jurisdictions, not the end of the world, but much more expensive, time consuming, and just much, much more of a hassle. So how do I avoid probate? Again, kind of going back for a minute, if you own anything jointly with somebody, that asset does not go through probate. It does avoid probate. Now, when the second owner passes away, if they still own it in their own name, then that asset is a probate asset. If you have something with beneficiary designation on it, again, avoids probate, fine. But the problem with relying just on beneficiary designations is that, you know, for the most part, you just name the person and you can't really meaningfully limit their use or access to it through a beneficiary designation. And so when you name someone as a beneficiary of an asset, if they're over 18 or sometimes if they're over 21, they're just going to get that asset. And so a lot of people would like to be able to exercise more control over those assets. And then the other big way to avoid probate is through a revocable trust. So again, the revocable trust, sort of acting as a will replacement, can solve the probate issue, because when you're still here, you take the assets that would otherwise cause probate. Your condo in Florida, your cabin in Wisconsin, your investment account here in Minnesota, your LLC interest. You retitle those into the name of your revocable trust, so it's no longer Brad, it's Brad as trustee of the Brad Revocable Trust. And now, when you pass away, that asset avoids probate. You know, I get a lot of questions as I talk through this planning with clients. Well, you know, either I have X amount of dollars, I must need a trust, or I don't have all that much, I must not need a trust. But I mean, it sometimes tends to go with asset values, but more meaningfully, it goes with type of asset and location of asset, not value of asset. So if you've got the sort of normal kind of financial assets here just in Minnesota, probate wouldn't be that big a deal if it were even necessary. But if you've got, you know, again, the maybe nominal financial assets here, but I don't even like $100,000 condo in Wisconsin, for example, probate's much more of a hassle. So you may still need a revocable trust, whereas that first person maybe would be fine relying on a will.
So Brad, we have a question.
Yeah, go ahead.
So you were kind of just talking about that. So is it just a conversation with an attorney that helps decide if I do want to put that trust into place, or what are the questions I should be asking to maybe decide, yeah, I'm okay with probate, or no, I'm not okay?
Yeah, I think you probably are most often going to want to have the conversation with an attorney. I mean, there are a lot of good, sorry, I'm having some technical difficulties. There are a lot of good resources out there online and whatever where you can kind of take a look at some of these issues. But I think it's, unless you've sort of lived it, and even if you have, you just lived a specific probate, I think it's good to get a sense from an attorney, you know, sort of what might be the right fit for you. And for what it's worth, I mean, I know this is true for me, but I believe it's true for most people who practice in this area. You know, no estate planning attorney should really charge you for an initial consultation. And so you usually can get a good sense from an attorney who does this within half an hour to an hour about sort of, for me, this is the kind of plan that would probably be the best fit, and then what the costs are that come with that. Yeah, I mean, you could kind of try and figure it out on your own, but I know it's a shock that the attorney is going to tell you to call an attorney, but I do think that that's probably the smart way to go. So I've been talking a lot about probate and avoiding probate, but now moving on to what's actually usually most people's focus when they think about estate planning is, you know, how does the plan work when, if for a married couple, let's say, how does the plan work when first spouse dies? how does plan work when we're both gone? And when I'm leaving assets to people, how am I leaving the assets to them? So that's really what we spend a lot of our time talking to our clients about when we talk about estate planning. So I guess I'll start at the bottom of this slide, which is taxes. I don't have any detailed slides in this presentation about estate taxes and gift taxes, and those, again, you can read a lot about them. They're theoretically in flux right now, though it's not looking that much like the federal system is going to change currently. But suffice it to say there is a federal estate tax system. Today, each of us have an exemption from federal estate taxes of $12.06 million. So it's a lot of money. The exemption is very high. That exemption is ticking up each year right now, slightly. Like in this last year, it went up about $350,000 roughly. But it's scheduled at the end of 2025 to revert to a lower number that'll be half of whatever it is basically that day. Ballpark, it'll probably be 7 million-ish come January 1st, 2026. But again, still, it's sort of historically high exemption. That's an exemption you can use when you pass away or while you're living to make gifts, or a combo of the two. You can use part of it while you're here and the remainder when you're gone. Now, for most people, they wish they only had a federal estate tax problem, because that would mean today that they have, for a single person, over $12.06 million, or for a married couple, $24 million. Right? I mean, that catches very, very few Americans. But we here in Minnesota, as you may all well know, we like our taxes, and so we have our own estate tax system still. There are not that many states left that have a standalone estate tax system, but we are one of them for now. And our exemption is much lower. It's $3 million. And another big difference between the federal exemption and the Minnesota exemption, aside from just the level, is that the federal exemption is what's called portable. Again, meaning that if there is a married couple, if first spouse dies, and let's say, given how their estate sits and how their estate plan is set up, they use, $3 million of their exemption. Under today's exemption, under that remaining $9.06 million of their exemption would get added on to their surviving spouse's own exemption. So now survivor has like a $22 million exemption of his or her own. And so the federal exemption is really, like, for married couples, essentially a joint exemption. In Minnesota, though, we have an exemption that is not portable. It's what I call a use it or lose it exemption. And so if the first spouse dies and leaves everything to the survivor, that's great, that's fine, no taxes, because anything you leave to your spouse is free of estate tax. There's an unlimited marital deduction from estate tax. But that first spouse then did not use their own exemption. So let's say there's a couple that has $4 million of assets, and I'll talk in a couple of minutes about sort of what adds up to get to these numbers. Let's say there's a couple that has like $4 million of assets, and spouse one passes away and leaves everything to spouse two. Spouse, no taxes then, again, because they're married. But now spouse two has $4 million of their own asset, passes away, only has a $3 million exemption to apply to those assets. So now we've got an extra $1 million over and above that $3 million exemption. And the taxes on that, the estate tax of the state of Minnesota, would be roughly $100,000, roughly 10% of the value. And that's a big tax. And had they had some planning built into their estate plan to make use of that first spouse's exemption, they could have made use of $6 million of exemption instead of just $3 million of exemption. So that's sort of the types of tax planning that apply to a lot of our clients. Once you get past the taxes, then you get into, okay, well, even given that, are we going to have sort of controls built around the use of the assets that I leave to people, whether it's to my surviving spouse, in which case you're allowed to put some restrictions in place, but not always as many. But more meaningfully, we spend a lot of time with our clients talking about, well, what about assets I'm going to leave to children or grandchildren or nieces and nephews, sort of lower generations? Do I want to just hand it to them? Do I want to keep it in trust for very specific reasons? So I want to keep it in trust for broad reasons. So I want to give them outright access when they hit certain ages. So I want to keep it in trust for their entire lifetime. You know, there's a lot of thought that goes into, as I note here, protecting the beneficiaries from others. You know, these kinds of trusts can provide meaningful creditor protection for the beneficiaries, but also protecting them from themselves. And sometimes there's a sort of a combo of the two. And then sort of just as important as the terms and the parameters you might put in place is who's going to be there to make these decisions in the meantime. So let's say even that your trust says, okay, if we're both gone, our kids can have their assets outright when they're 45. Well, in the meantime, you need someone there to say yay or nay when they ask for distributions for school or a car, or help them buy a house, or help them start a business, and you know, all their sort of general needs. And so we spend time talking about who's a good fit for a trustee, what kind of person isn't a good fit for a trustee. Do I want a corporate trustee maybe if I think I have challenging beneficiaries, or I don't want to burden people with playing the role of trustee? So that's a big part of the thought process that goes into the estate plan as well. Also very important, we've found, and I know,
Brad,
go ahead.
Yeah, we had another question come in.
Please.
I was just wondering about, okay, but these all sound great, but what if my spouse dies without the will?
Yeah.
Or without some of those things in place, what happens? And then what happens with like a second marriage if you throw that into the mix? How do we handle that?
So I guess answering the first question first, if somebody dies without a will, again, first you're going to look at beneficiary designations. So if you guys, you know, or the way title was held to those to the assets that the spouse was an owner or a partial owner of, if there are joint assets, those will pass by operation of law to the survivor. So the survivor can go to the asset custodian. Let's say it's an account at Cetera. You provide a death certificate, and there's some paperwork to fill out, but then those assets will just pass to the survivor. But if there's stuff that the first spouse owns in his or her own name without any beneficiary designations and without any co-ownership, and in aggregate they're worth more than $75,000, because there is sort of a small estate threshold here in Minnesota, then you would need to initiate what's called an intestacy proceeding, which is essentially the same thing as a probate proceeding, but it's what happens when you pass without a will. And then as far as second marriage, you know, part of what we do in our practice is help clients with prenuptial agreements. You know, does every couple need one? No. But sometimes for a second marriage in particular, and if you're each coming in with, you know, some level of assets, sometimes it's worth doing a prenup, not to even necessarily talk about what happens in divorce, but make clear that what happens if one or both of us dies, what we're allowed to do. Because otherwise, when you're married, you know, your spouse, each year you're married, is accruing certain rights to your estate without an agreement in place that would otherwise change that. And then I think, you know, in this kind of is a nice segue to this slide, a lot of the focus when we work with families that are in a second or later marriage situation is just the communication around it all, and sort of coming into it, you know, sort of here's our deal, and you know, we agree to do whatever for each other, but then we're allowed to do whatever we want for our kids, or you know, somewhere on that, you know, obviously it's a broad spectrum, but are we going to do everything for each other? Are we gonna do things, you know, certain things for our kids? Are we allowed to do whatever we want for our kids? And if you don't have a prenup in place, you guys can agree on whatever you want, but the surviving spouse would actually have the ability to kind of elect against their spouse's will. You know, does that happen very often? No, but the only real way you can ensure that it couldn't happen is through doing a prenup. You know, we find another key part of estate planning is the communication, and that can happen in multiple different ways. Sometimes, mom and dad or do the estate plan and then ask us to be part of a family meeting to kind of describe what mom and dad have decided. Sometimes there's more of involvement of the family in the decision process as it is occurring before it's sort of put in place. It depends on the family. It depends. There's some generational aspect to this. Sort of currently, the sort of older generation, certainly the generation that's in its 80s or so right now, traditionally hasn't been as open about these things with their kids. But more and more we're seeing it. And I think often if you're part of the younger generations, a good way to open the door to the conversation is not to make clear, you're not looking to find out what you get and when. It's more either that it's kind of going to be your problem, so you should have a sense of what's going on. Or I think more meaningfully, we find people are open to the conversation when their kids come to them and say, look, we're starting to do some of our own estate planning, and these are some of the questions that have come up. It made me wonder, what do you have in place? How are you thinking about it? And also, if younger generation is spending all kinds of time really thinking through and thinking deeply about how they want to leave their assets to their kids, let's say, that's great. But if grandma and grandpa are, the middle generation's mom and dad are setting up their estate plan to hand grandkids a bunch of assets when they hit 25, that's kind of meaningfully undermining what the kid generation is doing. And so I think sort of approaching it that way can often lead to meaningful conversation. And as is noted here, and as I've seen in practice, the Stein Financial Group is really good at facilitating these conversations. And you don't have to have your lawyer there. You don't have to have your accountant there. In some families, the whole sort of team is there. In some families, there's sort of one professional advisor tends to be kind of the quarterback, for lack of a better term. But I think, the more open you can be about it in the process, the more likely you're going to be able to preserve family harmony in the longer run. I talked a little bit about taxes a minute ago. I think we are still in a climate that allow for strong gifting opportunities. There's sort of a combo of, and I won't get too far into this concept, but the stock market has done quite well and continues to, but certain other assets like real estate, closely held business interests may be of a nominally high value, but through certain techniques, you're able to discount the value of those assets. The Congress and the IRS has talked about changing the law such that those techniques would not be available any longer, but for now they still are. Interest rates for now are still low, and even if they start to increase, they are still just sort of historically low. And then we have this historically high exemption. And so you may, for some people who are, certainly for couples who I think are over $3 million worth of assets, it's still worth considering, do I want to start maybe giving some of these away currently because I can, and because, I may not, they may take away my ability to do so as easily. But that being said, before, and so we get lots of questions about gifting, especially starting sort of last fall when Congress had proposed laws that would have greatly reduced the exemption amount. We get lots and lots of questions about, should I be gifting? Do I need to do it now? When should I do it? What should I do it with? How much, et cetera, et cetera. To me, that last question is the most important one, the how much. And, as I sort of joke, but I really mean it when I say to clients, what I don't ever want them to sort of sense from me or think they're hearing from me is, first that I'm reminding them that they're going to die, but then also that before they go, I'm going to make them give it all away, because that just isn't the case. I'm going to talk to clients about the opportunities available to them, but first and foremost, clients need to be comfortable that they have what they need to live the life they want to live before they start giving anything away, whether that's to other individuals, you know, their kids or whomever, or to charity even. We're always going to look to protect our clients' lifestyles first. And again, as noted here, but it's very true, Stein Financial Group is able to do all kinds of modeling for you to make sure that you really are in the position where you can do that before you really start having a meaningful gifting conversation. I've been talking a lot about amounts here that are high. You know, certainly 12.06 million is huge, 24 million is ridiculous, right? 3 million is a lot, 6 million is a lot. But even though you may not ever get a sense to really feel rich, so to speak, the state of Minnesota may think you are before you really realize it. And so when I talk about these asset values, what do we add up to see whether or not we're over these thresholds? You know, your house, net of any mortgage. If you own a business, your interest in the business. Retirement accounts, that's one sometimes people forget. You know, retirement accounts certainly are income tax advantaged, but they count as part of your estate when we're going to figure out if you're over these tax thresholds. Investment accounts, so you're non-qualified, you're sort of normal investment accounts, certainly. Anything that's owned in joint tenancy, if you're a joint tenant with rights of survivorship, again, like the way most married couples own their home here in Minnesota, at least, if one spouse passes away, half the value of the house counts when you're determining if they're at the tax thresholds. Life insurance proceeds. So again, this is kind of a misconception sometimes. Life insurance proceeds generally are income tax free. But if you own life insurance on your own life and you pass away, the death benefit counts in your estate. Because sure, of course, you didn't get a chance to spend that money, you died. But you had the chance, because you owned the policy, you had the chance to name the beneficiaries. And so the tax code says, well, you then are deemed to have owned that entire death benefit. So even, you know, if it's a term policy, it had no like nominal value while you were alive, but you still are deemed to have controlled and owned the entire death benefit. And so, you know, there are ways around that. Certainly spouses can own insurance on each other. You can use certain types of irrevocable trust for that. But that's one I think a lot of people maybe sometimes don't realize. Your cars, your boats, your other sort of toys, tangible personal property, jewelry, antiques, art. Sometimes I get questions about, well, you know, how would they ever know about that one? The answer is if there's an estate tax audit, one of the things they often ask for is your insurance rider to see what you thought was valuable and you were insuring. So, you know, the taxing authorities haven't, you know, it's not ever their first rodeo. And then another one people don't realize always is inherited assets. So if you inherited an asset, generally, at least in Minnesota, you don't pay tax on that from like an estate or gift tax system. The beneficiary of an inherited asset does not pay tax to receive it. There may be income taxes they later have to pay depending on how they inherited it, but when they sort of liquidate the asset. But the inheritance itself is not a taxable event to the recipient. But when you later pass away, those assets would count in your estate, and whatever they've grown to would count in your estate unless you receive them in certain types of trusts. So, you know, when you add up someone's house, retirement account, life insurance, maybe some inheritance from their parents, even though you may not ever like totally feel it, to the state of Minnesota, you may well have a large enough estate for it to be taxable. And so, you know, that's another reason not to kind of poo-poo the tax planning aspects of the stuff I've been talking about, because it hits a lot more people than you might realize. In a core estate plan, aside from the trust and will, there are a few other key documents that we focus on with our clients. There's the healthcare directive. Even if somebody hasn't done any of the other planning I've talked about today, often the first thing they'll have is a healthcare directive. You can often get one from your healthcare providers. One thing I'd note there is one kind of misconception is you're not appointing someone as your healthcare agent to make their own decisions about your healthcare based on what they believe. What you're doing conceptually is appointing someone to read your wishes that you put out in this healthcare directive, and then have them administer your healthcare based on your wishes if you're unable to communicate your wishes. Now, that all being said, I would not recommend appointing someone who you believe or you have concern holds very different feelings and beliefs about end of life related items. Because we've all read about the situations where that's an issue. Another document is a power of attorney, financial power of attorney. In Minnesota, the statutory form is what's called a durable power of attorney, which kind of actually works sort of the opposite of the way a lot of people think it works. The way people think it works, I believe, is that if I'm incapacitated, this person has the power to act on my behalf with regard to financial matters. The way it actually works is anytime after I sign this thing, this person has the power to act on my behalf with regard to financial matters, even if I become incapacitated. And sort of that second part is like, yeah, well, of course that's how it should be, but that is what the document says. And so, it's a very powerful position to hold. It's a very powerful document, and for that reason, obviously, you'll want to give some real thought to who you name. The way it works is beneficial in some respects because due to the fact that it's active the moment you sign it, you don't have to worry about like proving up whether or not someone's incapacitated, which can get messy and can be quite a challenge. So that's useful. But again, it's very powerful, so you just sort of want to watch it. Whether you have a will or a trust, it usually will say your tangible personal property, your clothing, collectibles, jewelry, artwork, your things. When you pass away, usually it'll say if you're married, it'll go to your spouse. If you have if you don't have a spouse but you have kids, it'll go to your kids, be divided among them as they determine in equal shares by value. Or to other individuals you might name in your will. But it also usually says, okay, that's generally the statement. But if I have certain other items I would like to go to specific people, I can create a separate document that says I want this thing to go to that person and that thing to go to that person, and that document will control it. It's called a Memorandum of Distribution of Tangible Personal Property. But it doesn't have to be on any special form. It could be, on these Post-its. It just needs to be signed and dated. And what I would say about the tangible personal property is, and we probably either in our own lives, hopefully not, but I've heard of situations where, that's really what kind of breaks up the family is the fight over the things. And, money and assets and financial assets are fungible, and people can argue about those, and they will. But obviously, there's often a lot more emotion associated with the things. And so what I would tell clients is if you're concerned that your kids are going to fight over a certain item of tangible property, they probably will. Because if you have a reason to think they will, there's something there. And you can short circuit that fight in theory by naming it to one or the other. Now, that'll give them opportunity to be mad at you, but it may well preserve their relationship. So I would recommend considering doing that. And then finally, kind of coming sort of full circle, I kind of started with beneficiary designations. We've talked a lot about tax planning and distributions to beneficiaries, and do I want it in trust until certain ages with a trustee and all that stuff. And that's all important and really is the focus of most of what I do. But you've got to also make sure all your assets that have beneficiary designations available within them are lined up so that they flow correctly through your estate plan. So let's say you spend a lot of time working with a lawyer to come up with a very complex tax planning structure, and then when you're both gone, you have very specific provisions you want for your kids as it relates to their access to assets and their use of assets. That's great. But then let's say you have a life insurance policy for $1 million that you sort of forgot about, that as a beneficiary designation just says your kids. Or even worse, let's say it says a charity. Well, if it just says your kids, they'll just get that asset. Even though you have all these trust terms for them in your will or your revocable trust, that beneficiary designation is going to control as it relates to that asset. Or if you had a charity named in there and you sort of forgot about it, even though in your mind you think it's going to your kids, actually when you pass away, those assets are going to that charity. So after you, or in tandem with doing your estate plan, you'll want to work with Stein Financial Group or on your own to make sure that the assets, the beneficiary designation and the titling of the assets lines up so that your plan can work as you worked hard to put it in place.
Brad, we've got another question here.
Please.
So we've heard that maybe 18-year-olds should have some of these documents in place because they're adults now. Could you maybe talk about that a little bit?
Yeah, I'm getting that question more and more. I think that's a good idea. Will trust, maybe not as important usually for 18-year-olds, but often we get a lot of questions every year now, like like August, before kids go off to school, to college. So more and more we're having clients put in place powers of attorney and healthcare directives for their kids. I'd also recommend, if they're going to school in another state, it makes good sense to do it here and in the state where they're going to be in school. A Minnesota healthcare directive or a Minnesota power of attorney is valid everywhere else, and vice versa, but it's much just administratively easier if you have one, like if your kid's going to school in Ohio or whatever. If you have one, Ohio healthcare directive, Ohio power of attorney, it'll be much easier to use. But yeah, I think that's a good idea, and we're seeing people do it more and more.
I guess part of that question is kind of why. Well, what's the importance?
Because once they turn 18, even though you're still, I'm certain, very much still their parent, in a lot of ways, in your mind, their guardian, you have no authority anymore to act on their behalf. And so, if heaven forbid they're in like a car accident or something in the hospital in my example, in Ohio, you may well not be able to talk to the doctors. And or if they need your help with their bank account, most financial institutions would not talk to you unless you're on the account, which you can obviously do that as well. So yeah, it's once they turn 18, they're their own legal entity at that point, and you don't have the ability or the right anymore to just kind of pop in on their behalf. And so thank you. And so that's a story. I'm happy to hang around for a little bit more and take any more questions. Otherwise, obviously feel free to follow up with your team at Stein Financial, or people are always welcome to reach out to me directly, and happy to be a resource.
Yes, thank you, Brad. Yeah, does anybody else have any other questions that they'd like to ask Brad right now? And there's Anthony too, so he can help field some as well.
Maybe, if we're lucky. And it goes without saying, Brad, you covered a ton of great information, stuff we get asked all the time. Right. And, I think you did a great job of summarizing the pieces here. I mean, by far the most common question, and you address this all throughout, that we get is, how can I minimize the tax hit that I may have to pay on passing assets? And that can range from, hey, I'd love to sign my house over to my kids. And then, we talk about the pitfalls involved with that. But, just for a general sense, I realize this is totally situation dependent. When you get that question, kind of what is your go-to answer in just vague terms at first?
How do I avoid the tax hit?
Yeah. If somebody says, hey, I've got this, that, and the other, what's the most efficient way? I realize it's totally context dependent.
No, I get it. I don't always want, sort of the tax tail to wag the dog, so to speak, because sometimes you could work to get to zero tax in any given estate, but sometimes, to keep using different metaphors or whatever, the juice isn't worth the squeeze or whatever. And so I think I usually start with, just getting a sense of the estate. And then also a lot of times it's based on, there's all this sort of, fear mongering out there about estate taxes. It's become such a political hot button. In Minnesota, it's, does it impact a slightly larger percent of people? Yes. Federally, I mean, it's way less than 1% of families are impacted by federal estate tax. And so even though it's this big political hot potato, it's it really doesn't hit as many people as think it hits them. And so first, I certainly get a sense of where they are asset wise. If they still really are in a tax situation, I talk through gifting sometimes, but then again, that goes back to making sure they have enough for while they're here, and then explain to them sort of the tax planning that's available. And then also, I didn't really talk hardly at all about this, but there's always a charitable option as well. And you can get very meaningful either income tax deductions or estate tax deductions from all types of charitable giving. And so, I'm not there to like push charity on clients, but you find out everyone's somewhere on the charity versus taxes spectrum. And some people say they're charitable. And I had one client years ago tell me they don't believe in charity. I don't know what that means, but I said, I'm here to tell you charity exists. So if you're saying you don't believe in supporting charity, okay, fine. But and that's fine. But then some people become more charitable when they realize that dollars are going out the door no matter what. So they'd rather go to charity than the government. Others really are more meaningfully charitable from the start. And so, I think I know this isn't a perfect answer, but I have to work first to find out sort of where they're coming from in a few different ways, and then can kind of help fit the puzzle together.
Yeah, and I think that's really well answered, because I think obviously it's so context dependent, but getting someone to sort of get in the mindset of thinking about how do you want to settle things? What's your ideal? Let's work from there is really the key. And you, any other questions in the chat, Kim, before I just launch into one?
No, I've not seen any come in at the moment.
Okay. Well, and everyone, please, if something comes to mind, please chat it to us, because I don't need to just listen to myself talk here. But one of the big, I shouldn't say a big issue, one of the very common things, Brad, that affects a lot of our client base and potentially a lot of the audience watching right now is qualified assets. And I know you went through this as well, but for a lot of people, we tend to work with a high proportion of former government employees, which means their retirement is their pension and their 457, usually now maybe an IRA that they've turned into. Now, as far as a trust goes, do you recommend, and again, context dependent, IRAs within trusts or not? Because I have some experience on this with my own personal family, and there's some pros and cons to really take into account.
And as I understand the rules currently, and you may well understand better than I do, for a spouse, well, and this also sometimes can get back to the second marriage question. When a spouse under today's system, after the CARES Act, the spouse is still the only one who can use sort of the life expectancy to stretch out a retirement. It used to be kids could do it as well, and or other beneficiaries. I guess I'll say since the change to either the 10-year pay down or drawdown period, or sometimes 5-year drawdown period, I will say fewer and fewer of our clients have chosen to put retirement accounts in trust for beneficiaries. I can't totally tell why. I don't know exactly why it's a different decision that's being made, but just anecdotally, that's what we're seeing. That being said, when there's a big retirement, a relatively large part of the estate is a retirement account, and it's a later marriage, then sometimes we will see people put them in trust for a surviving spouse, still just to ensure that the essentially the contingent beneficiary, the secondary beneficiary, doesn't get changed.
Right.
What are you guys seeing?
Yeah, no, I agree with you. And for the audience, a lot of you probably know this. We've tried to get the word out about this change, or maybe it's affected you. But what Brad's referring to with the change in 2020 is for non-spouse beneficiaries of an IRA or a 457 even, or a 401k. You used to be able to keep that account for the course of your life. If you inherited from a parent, you would continue to take distributions, but it would stay in your name for your life expectancy. What changed in 2020 was now you have, with an IRA or a Roth IRA anyway, 10 years to cash that account out completely. Now, a Roth IRA, not as big of a deal because it's all tax-free anyway. So it's kind of, you can take it all now or you can let it roll for 10 years and then take it all, but no taxes either way. But for an IRA, that can make a big difference, especially if it's a large amount. You know, having to take it all out of the account within 10 years, usually you're going to want to split that over the full 10 years to minimize the tax impact. And obviously now we're getting into minutia that depends person to person. But to answer your question, Brad, I would agree. I think most people these days are just using, and I want to, you know, make it clear to the audience, using the beneficiaries that are just attached to your IRA is a great way to pass it on. You don't have to make a special provision in a will or a trust in order to get those assets to the person you want them to. You can do it right on the account when you set it up, or change it at any time. So I agree, Brad.
Yeah, and no offense to, you know, Cetera or any other custodian, but it's not usually easy to deal with the custodians when there's a trust involved in a beneficiary designation.
Yeah, and for as someone who occasionally waits on hold online with some of these custodians,
you can confirm that. Yeah,
I can confirm that, and I'll say, and this is, I don't want to slander anyone, so I won't mention any names in particular, but trust company or custodians like Cetera or annuity companies are way better than banks. So stuff with banks is, and both from personal and from client experience, just a nightmare to deal with sometimes. Now, I'm not saying ill of banks. Everybody needs banks. We all use them, but it can be a tough process.
Yeah, I think what it just comes down to is kind of what you were saying, Brad, at the very beginning, how we title things and making sure our beneficiaries map the way we say and in our mind is what we want to have happen. It is almost what it comes down to at the very end. Whether you have a will, a trust, whatever the estate value is that you have, those two things are just really important and fundamental regardless.
Yep.
Kind of how you get everything set up. We did have a question come in, Brad. They said, great webinar. What sort of list of things should we have as a survivor? Like, what are the things that we need to be aware of as a survivor? Like that checklist of items.
Yeah, I got this question yesterday from a client. You know, if you have an estate plan, it's good to, we still physically give a physical copy to our clients, and, you know, put my card in there. It's like, you don't have to work with the lawyer who does someone's estate plan, but, you know, it's there sort of for ease of reference. Usually it's good to list your professionals, and including, you know, accountant, financial advisor, lawyer, if you have one. You know, more and more, there are always the questions about passwords and sort of online access, which obviously is a very important part of life today. The Minnesota, the estate planning community in general, and the law in Minnesota is still trying to catch up with like digital assets. And so, you know, more and more we're incorporating those provisions. Like as an example, there isn't really a digital asset provision per se in a power of attorney. And the issue is, getting back to, I'm more than happy to rag on banks if Anthony, if you don't want to. And they you know, the banks, for those of you who've had the pleasure of trying to use a power of attorney with a large financial institution, it's not fun. And they give you a hard enough time when you have the exact statutory form. And if you vary from it, they give you a very hard time. And, you know, I've had more and more clients asking to add digital asset provisions, not just in their will, but in their power of attorney. And there are real concerns about doing that because that's not in the statutory form. And so you may run into whomever at Wells Fargo, US Bank, whatever, that won't accept that power of attorney. And so, whatever, I mean, we're trying to figure that all out, but that's something to kind of keep in mind. So I think regardless, is it the best like cyber protective idea to keep a list of all your passwords? Of course not. But, you know, I do think you know, some of these like these these ones where you can have a password for a specific thing that then opens up the passwords to everything. Those, may well be a good idea. Because and then sometimes I do honestly think it'd be a good idea to, like, if you're putting together kind of a kit for someone who, something happens to me, go look at this. I actually think having your tax return available is useful. Because I'll tell you, sort of looking at it a different way, when we have people who have let's say a parent pass away and they've had no involvement in their financial life, and then it's like totally disorganized, what they end up doing basically is going through, like, waiting for like a few months cycle of mail, maybe getting into their email if they can, and then looking at their tax return and trying to figure out where they had accounts. And so if you can kind of short circuit all that, that'd be useful.
Brett, did you say at the very beginning, do you guys have a list that you share with people, like, of survivors?
No,
Like,
I can't claim that we do.
no, I was just curious if you did.
Yeah, no, it's a good
question.
question.
I might ask you if we could share that with folks.
No, I can't claim that we do, unfortunately.
All right. Well, it is 3:01. We have officially used up an hour, and I don't see any other questions coming in. So I think we'll wrap it up. But if anybody has any other additional questions, Brad's contact information is in the beginning. We'll definitely follow up with that. And of course, you know how to get a hold of us here at Stein Financial Group. But thank you again so much, Brad, for your time. I thoroughly
thanks for
enjoyed
having
it.
me. It was a pleasure.
Yes.
Take care, everyone.
Awesome. Thank you.
All right.
Bye, everyone.
Thanks, everybody.